Hello everyone, my name is Preeti Pahwa. I am partner eMindsLegal. We are a law firm based in Gurgaon, Haryana. I am a company secretary and a lawyer with about 22 plus years of work experience and have been practicing under this law for almost 7-8 years now. I am on the ICC of various corporates as external member. I also have hands-on experience of handling a lot of investigations, handling a lot of complaints, personally taking care of these workshops with the companies, with the masterclass conducted by the Institute of Company Secretaries of India, as well as various management institutes. So let me just start this webinar today with my presentation. Let me just share the screen, please. I hope you're able to see the screen. All right. So the topic for today is compliances under this law called Sexual Harassment of Women at Workplace, Prevention, Prohibition and Redressal Act of 2013. This is a very sensitive yet very important law to be understood, to be complied with. Before we start understanding the law and its compliances, let me share a very interesting video.
We see it happen everywhere, at any time.
78% of women have experienced sexual harassment in public spaces.
Like a suggestive comment,
A sexually explicit touch,
an inappropriate gesture,
or being followed. And it threatens our self-worth.
it takes over who we are.
We see it happen, but stay cautiously silent and uncomfortably look away.
maybe because we don't know what to do.
How to help.
Or how to combat the situation. The time has come to keep our heads up and to stand up for each other against street harassment.
And everyone can be part of the solution.
Sorry, I'm gonna pay for it.
Excuse me. Is this yours?
Can you help me, please? I'm looking for this direction.
L'Oreal Paris and the nonprofit organization Hollaback have joined forces to teach men and women how to combat sexual harassment in public spaces with simple but impactful actions.
So this video showed some statistics, not a very interesting site though, but I believe, you know, as a female, I believe that most of the females have either faced sexual harassment themselves or have been a witness to the sexual harassment of others, you know, in front of them. And most of us have not been able to take any action during that time. Sad but true. Yet times have changed now, and time has come to combat such kind of instances, to push back the harassers, and to ensure, you know, to start saying no, and to ensure that these kind of instances do not happen. So, so this was a beautiful video. I found it so interesting that I wanted to share with all of you. So why are we here today? The agenda for today's webinar is to understand, sorry, to understand what is sexual harassment, who is an employer, who's an employee, and what is a workplace as defined under the law. What is the role of IC, which is internal committee? What is the grievance redressal process in case such kind of instance happens? What is the punishment that is defined under the law? The compliance under the POSH, which is defined under the law and under various other laws. And how do we build a culture of prevention? The last bit is very interesting and important, because if we have a culture of prevention in our organization, the above 6 dots generally, although we will be required to comply with the law, however, the physical applicability or the complaints would not arise. So such a culture, beautiful culture in our organization, that that's a clean environment, compatible environment for everybody. There is an inclusion, there is diversity, no instances of harassment. And that's how the intention of the law getting achieved. Why does it matter? So why are we sitting here today, attending the webinar and understanding the law and the legalities and the complications and the compliances involved? Because it has a serious impact, first of all, majorly on the victim. Actually, it has a very serious impact on the victim. Not just her self-esteem goes down the drain because of such incident. People start getting judgmental about her. So comments such as, she used to dress up like this. Iske saath to, this was bound to happen with her. Passing comments like she was over friendly with her colleagues. This was bound to happen. So even the family starts questioning her that why did this happen with you? What did you do? Whereas if the victim has suffered an instance of sexual harassment, what is her fault in that? So she did not kind of encourage somebody. She might not have encouraged somebody to treat her the way she was treated. However, she faced that sad incident. And again, the judgments are being cast on her. So her self-esteem goes down the drain. The sense of security, the sense of confidence is not there. She loses the confidence. Her ability or the confidence to handle the work for which she was hired, she loses that confidence, and people start getting judgmental against her. So she may face physical injuries because of the incident, and she may also face psychological issues which might need medical attention. It may be as severe as that. Coming to the workplace, such kind of incidents have severe repercussions on the workplace, because there is negativity all around, and not only just about the victim, but the person against whom she files a complaint or she blames somebody for sexual harassment. People start getting judgmental against him also. So gossiping, coffee machine gossips happening all around the organization. The productivity of the workplace goes down, and there is always a negativity spread around. The impact on the business, again, it can be very severe, because just imagine a newspaper test where the name of the organization appears in the newspaper for instances of sexual harassment. Imagine where the brand name goes down, how the brand name goes down. So it takes years and years for a company to build a brand name, and one such incident of sexual harassment which gets circulated in the media or on the social media, which is all prevalent. So the brand name goes down the drain. It may be difficult for the business to attract good talent in terms of employees. The clients might not want to deal with such kind of organizations. The customers, the vendors also would not want to engage with such kind of companies. And where the businesses do not follow the compliance prescribed under the law, in those severe circumstances, even the business license under the law, under the POSH law, is bound to get cancelled. So that severity is laid down under the Act. Okay, let us take some examples of what are the offensive acts or behaviors which may amount to sexual harassment. One is by way of touch, violating somebody's space. Now, space is, you can't define the term space. Actually, it is something which everybody needs to function comfortably. I need a space to sit and around myself, so that if somebody tries to come too close to discuss something, to look into my laptop screen as to what I am doing, I might feel uncomfortable. So it's not about maintaining a 2 feet distance or a 3 feet distance. It's about a personal space which everybody needs. And if somebody tries to enter that particular space, the personal space, the person feels uncomfortable. And therefore, we should, as employees in the organization or as individuals also, appreciate and respect others' space. Patting, pinching, grabbing, kissing are very overt form of offensive acts, and they are, if the female feels so, they are bound to be complained against as sexual harassment. Second is using power position to request dates or sex. So a supervisor repeatedly asking somebody out for, asking a female colleague out for a lunch. or for a cup of coffee when she's not interested. She's repeatedly saying no, that, or not saying no directly, but she's trying to avoid such kind of lunch dates, coffee dates, dinner dates, by giving various, excuses. I have got work at home today. I've got guests at home. I've got a lot of work. Let's not do it. So repeated requests when you're being refused, again, they might be offensive to a female. And for the females also, let us not find out excuses to avoid such kind of things. Let us start saying no in the first instance. If you're not comfortable or you don't want to go out with somebody, say no in the first instance. Impeding, blocking somebody's movement when they are in the corridor, on the office floor, trying to impede or block somebody's movement when somebody is coming out of the elevator, and then just laughing it out, just trying to lighten the mood. However, the female might feel offended. Repeated welcome propositions or sexual flirtations. Again, whenever I take a workshop, one or the other person always comments that it might be a healthy flirtation. So frankly, I have not yet been able to find out the difference between a healthy flirting and an unhealthy flirting. It is all the perception of the female. So under this law, the perception of the female holds utmost importance. If she feels uncomfortable, that means the act is not right. The behavior is not correct, and she might go ahead and file a complaint with it, against it. So there are certain more examples like selection based on conditions. For example, the casting couch, you get selected if you will so giving an offer to a female, job offer to a female on the condition that if you give me sexual favors, you get selected for this particular job and you'll get all the bonuses and the perks and everything. So this is obviously an offensive act, and it will amount to sexual harassment if the female feels so, and if the female files a complaint. Threatening with the loss of a job if she does not cooperate with the boss or the supervisor. Reduce promotion opportunities. Again, these are like this for that, tit for tat. So if you do not cooperate, for the female, the statement is, if you do not cooperate with the male colleague or the colleague or the supervisor, then you may not get what you deserve. You may lose your job. There may not be any promotion opportunities. There may not be good bonuses for you. Your KRA might get screwed. So all that. Using force, like molestation, physical assault, and rape are very overt forms of sexual harassment, and they're bound to be complained against. Certain more examples, for example, staring or looking a person up and down, you never know. For example, there was a complaint raised against a male colleague by a female colleague, where she said that whenever I enter the office floor, I find him just staring at me till the time I reach my desk. So he's always following me with his eyes. So when this male colleague was asked why you do that, he says, I generally do not take care of what I'm looking at. I'm just thinking with my open eyes. So I do not bother where I am looking. So again, just a suggestion for such females who feel that somebody is kind of staring at them, just go and confront them. Say that, do not stare at me, otherwise I'll file a complaint against you. And for for the opposite party, I'm just not taking saying that it can be only males. It can be males, females, third gender who can be complained against. So therefore, the other party also needs to know and needs to be careful as to their looks being interpreted in a wrong manner. So better be careful rather than sorry, right? Making sexually oriented gestures, showing derogatory objects, pictures, cartoon, letters, emails, magazines, flyers, posters, drawings, WhatsApp messages, Instagram posts, all those things. So they may be complained against if the female perceives them to be the subject matter of harassment. So we have to be extremely careful when we're working in the organization. In terms of examples for verbal communication, any direct or subtle pressure or repeated requests for dates or sexual activities. We discussed this earlier. So somebody asking continuously a female out for a dinner or for a lunch, despite her saying no every time. So either the male should understand and also, and or the female should in the first instance say no. So both ways this needs to be handled. Asking questions about personal life, now very tricky, very, very thin line, because we attend, we are in the office for the best part of our lives, so morning 9:30 or 8 o'clock we leave our homes for to reach to our office, and in the evening till 6:30, 7:30. So best part of our days gets spent for office, in office. Now we make best friends around. There are people whom we want to share a lot of our personal life stuff. There may be people whom we do not want to share our personal stuff with. So if my colleague or my superior or my boss starts asking question about my personal life as to how your relationship is with your husband, or do you have a boyfriend, or what level is your relationship with, I might be uncomfortable. So these kind of questions get generally asked and discussed between the friends. Not everybody can ask such questions, and not everybody is bound to answer such questions. So for people, for the opposite side, where we should be for specifically for males, for example, they should know where to draw the line. Stop asking personal questions. No, why? If you sense that the female might get uncomfortable, or if the questions are such that generally do not get asked in the office scenario with the colleagues, stop asking such questions. And for the females, if you feel uncomfortable, please say no in the first instance. I will repeat this time and again, because saying no is the most important aspect which everybody should learn. It's an art to say no, so learn to say no. Passing lewd comments about individuals' body or sexual activities, passing dirty sexual jokes, comments, whistling, etc., etc. Writing suggestive or sexually explicit letters, notes, emails, invitations, poems, messages, sending unwanted cards and gifts, etc. For example, I, as an external member of an IC, received a complaint against somebody who, the male colleague, sent an extremely expensive perfume with a huge bouquet of flowers to a female colleague's home on her birthday, which she wasn't expecting. So everybody in her house started questioning about why this guy sent you in 8,000, 10,000 worth of perfume. What is your relation with him? Again, judgmental comments like, do you go office for this? Family can pass such comments. And then the female got so annoyed and so agitated that the next day she filed a complaint with the IC. So again, this was an unwanted gift for her. She wasn't expecting, and she felt bad after receiving that. Writing the online social media postings, derogatory online social media posts. Social media is all prevalent, and believe me, it's so easy, and all of us know that it's so easy to post anything and everything on somebody else's wall. So we have to be extremely sensitive about the fact that a female's friends and family members are there on her social media handle, and whatever we are writing, it's a public domain, and everybody in the friend list may be able to read that and interpret in his or her own mind. So therefore, be sensitive enough before you write on somebody's social media handle. So here, under the law, the thumb rule is any unwelcome is a very important word here, any unwelcome physical, verbal, or non-verbal conduct of sexual nature may be sexual harassment. If the female perceives it to be sexual harassment, the conduct may be physical, like touching, patting, pinching. It may be verbal, by way of what you are saying and what female is interpreting and she's feeling bad. Or maybe non-verbal conduct. For example, two people are standing in the corridor in the office, and after office hours, and discussing some pornographic content on their phone, showing to each other and just laughing and being merry, feeling merry. And a female colleague who's working, in the office in the late hours, and she overhears the stuff and she starts feeling uncomfortable. So the content wasn't directed at her. The content wasn't for her. She wasn't involved in the discussion. However, since she feels uncomfortable, she gets a right under this law to file a complaint against them. So it was a non-verbal conduct of sexual nature. Okay, moving ahead. Coming to the law. There is a clear-cut definition of sexual harassment under the law. The law says any physical contact and advances will be sexual harassment. A demand or request for sexual favors is sexual harassment. Making sexually colored remarks is sexual harassment. Showing pornography is sexual harassment. So these four circles, from top to the right hand side and then going up, these four circles are specific acts of sexual harassment defined in the law. However, if you read this with circle, which says any other unwelcome physical, verbal, or non-verbal conduct of sexual nature may be sexual harassment. So it's an inclusive definition and not exhaustive. It may be a physical contact advance, it may be a demand or request for sexual favor. If such kind of specific acts happen as are defined under the law, they will be an instance of sexual harassment. However, apart from these four specific acts, if the female perceives any other act which she unwelcomes, with a conduct which is of sexual nature and which the female unwelcomes, and then she gets a right to file a complaint under this law with the IC. Coming to what circumstances can amount to sexual harassment, there are two circumstances which, if they are related to an act of sexual harassment, will be a sexual harassment under the law. One is quid pro quo. Quid pro quo means this for that, tit for tat. So promise of preferential treatment in employment in return for giving sexual favors. Threat of detrimental treatment in employment for refusal to give sexual favors, and threat about present or future employment status for refusing to give sexual favors. So this is called quid pro quo. Creating a hostile working environment where a female refuses to give sexual favors. For example, interfering with her work or creating an environment which is intimidating or offensive or hostile, and she feels uncomfortable to perform her duties. Or humiliating treatment likely to affect her health or safety. For example, a female which has always been an A performer as per her KRA for all these years, and once she refuses to give sexual favors, her KRAs go down to B or C or D, and then she starts facing humiliation from her superior or boss, saying that who gave you this job? You are not at all eligible to work here, and you're a dumb, you're a duffer, and whatnot. So she feels humiliated. The teams are asked not to cooperate with this female by saying that let her prove herself. And these are just examples. These happen in the real life. So such kind of humiliating treatment or hostile working environment which affects her health or safety may amount to sexual harassment. Again, coming to what is not sexual harassment. Now, wherever, I've seen in real life or in the cases that I've handled, if there is a female, and she starts feeling harassed, and the opposite side is a male whose behavior she says that she's feeling harassed by, generally, she files a complaint with the IC for sexual harassment. There may be instances where it might turn out to be a workplace harassment, which is like, work pressure. Now, harassment is one word which gets used very loosely, very lightly. I'm feeling harassed. There's so much of work that I'm feeling harassed. Now, related pressures cannot be termed as sexual harassment just because your boss is a male and you are a female, or your colleague is a male and you are a female. Just because a female is feeling harassed because of work pressures, it can't be sexual harassment. So we should also understand what is not sexual harassment. Following up on work absences, and I have handled such kind of complaints. A lot of time people ask me, so should we stop questioning our female colleagues or female subordinates about why they are absent or why they are not completing their job? We get scared. The males say that we get scared that if we ask them, they might file a complaint against us. So this is not sexual harassment, because following up on work absences, somebody is not working as required or taking too many of leaves unnecessarily, that can be followed up with. Please don't be scared. Requiring performance according to job standards. So KRAs are defined. Somebody is hired to meet those KRAs. If somebody is not meeting, even if she's a female, she's bound to be questioned. So that will not amount to sexual harassment. Reprimanding somebody in relation to work or meeting targets, again, very, very common. If a female gets scolded, she doesn't get a right to get up and file a complaint with the IC. And for females, please stop doing that. Work-related stress. Again, like I said, work-related stress will not be sexual harassment. It may be workplace harassment. It may be stress. It may be a lot of work, but it's not a sexual harassment. Touching, brushing against, pushing without a sexual connotation. Like, again, it's without a sexual connotation. So there may be instances where somebody can just brush apart, brush aside, or maybe a female gets touched, patted on the back or on the shoulder just to gain her attention. That may not be a sexual harassment instance. Giving constructive feedback about work, very simple. Coming to the law again, who is an employer? The law defines employer as, for any government department or organization, the head or notified officer is an employer. For any other workplace like organizations like companies, private limited, public limited, branch offices and all that, any person responsible for the management, supervision and control of the workplace will be an employer. There is a person or board or committee responsible for formulation and administration of policies. So that person or the board or the committee who is responsible will be the employer. For a dwelling place or house, like our own houses, where we have house helps, maids, male helps, drivers, etc., etc., a person or a household who employs or benefits from the employment. For example, for my house help, I am the employer. So the law has defined an employer not only for organized sector, but for unorganized sector also. For the maids, domestic helps, for the people who are labor class, who are working on the roads and building the roads or the flyovers, etc., etc. So they are also or the shopkeepers or the employees working in shops, which is an unorganized sector. So everybody gets covered under this law. Who is an employee? Again, very important, because this determines whether the person gets covered under the law or not. Who's an employee? Somebody appointed directly or through a contractor. So a permanent employee or a contractual employee, regular, temporary or ad hoc employee, with or without remuneration or voluntary, because there are, in my experience, I've seen people coming in our firm, for example, students coming in our firm and requesting us to let them work for 15 days on a project. They are not expecting or they're not getting any remuneration, but still for those 15 days where they are coming and sitting in our organization, we become their employers and they become our employees. Under express or implied terms of employment, not every organization issues appointment letters till now. So there may be organizations which hire employees basis implied terms of employment without an appointment letter, without an offer letter or whatever. Still, the person who's contributing or who's working with the organization becomes an employee. Any probationer, apprentice, trainee, etc., etc., all these become employee for the period that they are serving the organization. Domestic worker in a dwelling place or household is also defined to be an employee. Now, what's a workplace? Very, very important, because people say that this incident did not happen in the office. This happened outside the office. So therefore, the law has defined the workplace to be any place visited by the employee arising out of or during the course of employment, including transportation provided by the employer. Therefore, any parties which are the offsites, the parties which are sponsored by the organization, travel by train, by air to a client site, that travel also gets covered. Cab facility given by the employer becomes a workplace. Of our office building, again, where we are working, that's a workplace, of course. And this small cute hut that I've put in the presentation this represents the work from home scenario. So our homes during the work from home scenario have become a workplace, and it's not that since a lot of us are working from home, the instances of sexual harassment are not happening. So physical sexual harassment has converted into virtual sexual harassment, sad but true. So there are instances of virtual sexual harassment happening in the current scenario also, in the work from home scenario also. So like I said, let's discuss let me share some instances of virtual sexual harassment with you. Okay, let's see this very interesting video.
Before we end this meeting, I would like to say one thing. Pandemic है, जान बचाओ और अपनी जॉब भी. और जॉब बचाने के लिए बहुत मेहनत करनी पड़ेगी. एक्स्ट्रा काम करना पड़ेगा, एक्स्ट्रा टाइम देना पड़ेगा हर दिन. नहीं तो सबकी जॉब गई समझो. Do I make myself clear? Come on, let's get back to work. प्राची, तुम जरा रुकना. तुमसे कुछ जरूरी बात करनी है. Yes, bye. क्या बात है प्राची? तुम मेरे मैसेजेस का जवाब क्यों नहीं दे रही हो?
So actually I was not well.
जॉब बचानी है ना, तो कुछ एक्स्ट्रा करना होगा. समझ रहे हो ना मेरी बात?
Hey guys.
Hi. Hi Tanya. What are you doing? You just got done with the meeting.
Is it? तुमने मीटिंग में कहा ना कि एक्स्ट्रा मेहनत करनी होगी, एक्स्ट्रा काम करना होगा, तो मुझे लगा कि सीनियर मैनेजमेंट को शुरुआत करनी चाहिए. प्राची, क्या कह रहे थे बॉस?
मैम सर फिर से वो पर्सनल मैसेजेस की बात कर रहे थे.
पीके, पढ़े मैंने तुम्हारे पर्सनल मैसेजेस. तुम्हें पता है ना जॉब किसी की भी जा सकती है.
No, you're getting this wrong.
We need to
This
talk.
is a misunderstanding.
We need to talk. Prachi, are you fine?
Yes ma'am.
Sure?
Yes.
Don't worry. We'll take care of it. Okay? Take care of yourself.
So harassment can take place virtually also, and that's a small example of how it can happen. Few instances which got reported. Let me share these instances for virtual sexual harassment. One woman who chose to remain anonymous said the director of the company used to take screenshots of emails which he shared with colleagues, making derogatory statements and implying that the photos look like we're doing sexual acts. So strange but true. One more instance reported where the female had complained that I have had multiple calls with clients where they've made lewd comments about how I sound. The most common is you sound sexy, you should be working as a phone sex operator. Another victim said that she received highly sexual phone messages from a colleague who got the number from a work WhatsApp group, and he started messaging her privately. The chat started with his sexual desire for her. Okay, so these were few instances of virtual sexual harassment. Let's see what law says about the grievance redressal process. First of all, let us understand what's the appropriate forum for filing a complaint. That's very, very important because we should know where the complaint needs to be filed if such kind of instance has happened. And it's not only for females, it's for males also who know that one of their colleague has faced such kind of harassment instance, and he or she wants to support that female who suffered such kind of instance. So what is the appropriate forum of complaint? One is ICC or IC, which is in case the organization has more than 10 employees. All companies have to have an internal committee, which is called IC, and the complaint needs to be filed to the IC. Next is in any other cases where either the number of employees are less than 10, or still there are organizations, despite the number being more than 10, they still do not comply with the law. For those organizations, the local complaints committee, which is established by the labor offices in each district. So each district has a local complaints committee. In these committees, females from organizations where either those organizations have less than 10 employees, or maybe they belong to an unorganized sector, or if there are more than 10 employees, there are no ICs existing in those organizations. So where there are no ICs, there is a local complaints committee. The complaint needs to be filed with it. Third is police, in case the aggrieved woman wishes to approach. And the fourth one is SheBox, which is an online sexual harassment complaints portal set up by Ministry of Women and Child Welfare. So where here the female can file a complaint online. Composition of IC. So every organization with 10 or more employees need to have an IC. The composition being one presiding officer who's a woman employed at senior level at workplace from amongst the employees. Not less than 2 members who are employees of the organization. 1 external member from NGOs or law firms or associations who are committed to the cause of women. Half of the total members shall be women in every IC. IC has the power of civil court, the power to summon and enforce the attendance, examining somebody on oath and requiring production of documents, witnesses, etc., etc. Who can make the complaint? So either the aggrieved woman herself, legal hire, relative, or a friend where she's not able to do that herself, a co-worker, guardian, qualified psychiatrist or psychologist where the female suffers mental issues and she's not able to do that herself, an officer of the NCW or the State Women Commission, on any person who has the knowledge of the incident or authority under whose care she is receiving treatment or care, etc. Most important, the complaint needs to be in writing and submitted with the IC of the organization. Essentials of a well-written complaint, very, very important, because this slide specifically has come out of after a lot of practice in the law, after a lot of instances that have happened, have been sorted out by us. So therefore, for a well-written complaint, the details of the aggrieved woman and respondent both needs to be mentioned along with the reporting structure amongst themselves. The report cannot be anonymous, this means. So an anonymous complaint will not be entertained by the IC. Name of the aggrieved woman and her details should be mentioned in the complaint. It should be addressed to IC and not the employer or HR. Concise, simple language, easy understanding of the complaint, and details of the exact incident, date, time, witness, whatever she can include. Circumstances preceding and following the incident need to be recorded. Whether the complainant asks the respondent to desist from the unwelcome act. Again, like I said, for the females, it is high time that we start saying no in the first instance. And if we've started saying no and still that act continues by the respondent, then in our complaint, it should be mentioned categorically that I had categorically told him not to behave with me in such a manner, still he continued, and therefore I'm writing this complaint. Just an example. Append as many documents as possible in whatever format, WhatsApp, emails, call details, photographs, recordings, SMSs, etc., etc. Do not state any fact that is false or incorrect, because that's going to hamper the investigation and that's going to be against the complainant. And the relief that is sought from the employer, the female should mention that what relief she is seeking from the employer. The relief might be as simple as a written apology from the male colleague, or it may be as serious as terminating the male colleague, or it may be for transfer of either of them from that place, etc., etc. Now, coming to the dispute resolution mechanism, there are 2 ways of doing it, either through conciliation or through investigation. So conciliation means sitting across the table, discussing the matter and coming to a conclusion and closing it. Where the complainant requests for a conciliation meeting, the IC can convene a conciliation, should convene a conciliation meeting and take it under conciliation and come to a conclusion. So complaint gets filed within 3 months of the incident of sexual harassment to the IC, and it can be filed beyond 3 months, but there should be justifiable reasons, and the IC should record it in writing and then condone the delay. However, within 3 months is what the law prescribes. Here, the aggrieved woman requests for a conciliation, and then the IC will call both the parties, sit across the table, and come to a conclusion, logical ending of the complaint. The settlement gets recorded, copy of the same is given to both the parties, and then there is no further inquiry. Here in conciliation, the settlement cannot be monetary. So the victim cannot say that if I may be paid a monetary settlement amount for me to close the complaint. No, that's not allowed under this. Coming to inquiry, where the female where the complainant aggrieved woman says that I want a complete inquiry into my complaint, the IC has to follow the inquiry procedure. And the procedure as defined under the law is that within 90 days of the occurrence of incident of sexual harassment, complaint gets filed with the IC. Now the IC has to act like a quasi-judicial body. Copy of the complaint will be provided to the respondent within 7 working days, and the respondent gets a time of 10 working days to respond on that complaint. Then the copy of the response gets provided to the victim or aggrieved woman. Then she will go through it. She might have any additional instance or document to share or witness to be produced. Then she will respond to it. There may be multiple to and fro of documents. Complaint, respond, complaint, respond. Then, however, the IC gets a total of 90 days time to close the complaint, complete the inquiry. And within these 90 days, there may be 10 sittings, there may be 1 sitting, there may be 15 sittings, depending on the complexity of the matter. And however, 90 days period is specified under it's fixed. For all inquiry meetings, 3 members of the IC are mandatorily required to be present, including the presiding officer. So the quorum is 3 members of IC, including presiding officer. Okay. Inquiry, once the inquiry is completed within 90 days, inquiry report gets provided to employer within 10 days from the date of completion of inquiry. So from the date of filing of complaint, it's a 100 days process defined under the law. And cut to cut, it has to work. You cannot, say that one was not present or the aggrieved woman was not present for the hearing or the respondent wasn't present. No such excuses. Here, as a resultant, so the outcome of the inquiry can be either the allegation gets proven. So IC will pass its judgment for taking action, suggesting action for sexual harassment as misconduct, where the allegation doesn't get proven. For example, there were not enough witnesses, or the female, I'm not saying that the incident might not have occurred. It might also be the scenario where she has not been able to prove it. And therefore, the employer cannot take an action, or the IC cannot recommend an action to the employer. So no action by the employer. Where, however, it is proved that the female with a wrong intent or a malicious intent filed a complaint with the IC to settle scores with the colleague, or maybe, I don't know, maybe just like that. So similar punishments are also provided under the law for the females also. So females have to be wary of the fact that they can also be punished. Both the parties are free to appeal to the appellate authority within 90 days. Now, in the interim, this 90 days period, the aggrieved woman can also request the IC to give her some interim relief. For example, the law has prescribed interim relief such as transferring the aggrieved woman or respondent from the place of work, granting paid leave to aggrieved woman up to 3 months. Now, this is up to 3 months. So the aggrieved woman cannot claim it as her right to get a 3 months paid leave. I have personally faced an instance where the aggrieved woman said, I would not say requested, because she insisted or ordered the IC that it is my right, I should be given a 3 months paid leave. So when asked, what will you do after 3 months? Then she said, I will see what I have to do. But at the moment, this is my right. And when we showed her that it is up to 3 months, she started questioning on the interpretation of this by the IC. So again, it's not a right. It's the female, the aggrieved woman can request, and depending on the circumstances or her physical or mental condition, the IC may grant paid leave to aggrieved woman up to 3 months, and it's a paid leave. Restrain the respondent from reporting on workplace of aggrieved woman and assign reporting of aggrieved woman to another officer. These 4 reliefs, interim reliefs, are provided under the law. Such other relief as may be prescribed from time to time under the law. Now, where the action, where the sexual harassment gets proven, what action can be taken by the IC? What actions can be recommended by the IC? The respondent may be asked to submit a written apology. A warning may be issued to him. He may be reprimanded. His promotions or pay rise or increments may be withheld, may be terminated. Some counseling session may be advised for him, or in extreme circumstances, a police complaint can also be filed against him. Now, here under inquiry, there is a provision for compensation. In conciliation, there was no compensation, but after inquiry gets completed, if it is found that the female was sexually harassed, there is a provision for compensation, which is basis the loss in career opportunities faced by her, the medical expenses faced by her, and also it also depends on the income and financial status of the respondent. Apart from this law, there are other criminal laws which provide penalty for instances of sexual harassment, like IPC section 354A provides up to 3 years of imprisonment for the offense of sexual harassment. IPC 354B provides an imprisonment of 3 to 7 years for assault or use of criminal force to women with intent to disrobe her. IPC 354D for stalking provides imprisonment for up to 3 years. IPC section 509 provides for an imprisonment of up to 3 years for any word, gesture, or act intended to insult the modesty of a woman. Any harassment by an indecent portrayal of women in books, films, photographs, painting, etc. Imprisonment up to 2 years is prescribed under the law called Indecent Representation of Women Prohibition Act. So these are, apart from the anti-sexual harassment laws, the penalties, imprisonment provided under other laws. How can we help as professionals? How can eMindsLegal help you in compliance under the POSH? Very important. So like in the beginning of the webinar, I shared that I have a lot of experience, about 7-8 years of experience in handling these laws, and as a law firm, we've got an excellent team which takes care of the compliances under this law. So we can support by drafting a POSH policy, and POSH policy is the basic document which has to specify, which has to be very specific and detailed. It should mention, not only about the law, but about the intention of the organization. So the mission of the organization to curb such kind of instances happening in the organization. Constituting an internal committee. Like I mentioned, I am a part of various ICs as external member, and I contribute, basis my experience. Nominating an external member, ensuring notices and displays which are required under the law, conducting awareness workshops for employees. So what we did today in the webinar was in brief, however, the workshops are extremely detailed and interactive so that the employees are aware of their rights and obligations under the law. They understand how to moderate their behavior in the organization, what may amount to sexual harassment and what will not amount to sexual harassment. Like they say, this was just a trailer. The movie is still remains to be seen. Conducting capacity building workshops for IC. So it's not about training your employees, just your employees. It's also important to have capacity building workshops conducted for the IC members. Why? Because the IC members are like employees just like us, they might not be lawyers, they might not be aware of the such law. They will only understand the law through these workshops that get conducted for the employees. However, once we receive such kind of complaints, then the IC members should be competent enough to handle. They should know once they receive the complaint, what is the next step immediately to be taken, and how to analyze, how to interact with both the parties. So all these things get taught to them by way of capacity building workshops. Then investigation of POSH complaints. If there are any POSH complaints, eMinds can help you in investigating, maintaining records of IC, inquiry reports, attendance, etc. Disclosure in the board's report. Again, that's very, very important, because it's not about annual return filed under the law. It's also about the director's report that gets filed with the Ministry of Corporate Affairs in case of companies. Disclosure is required in the board's report also. Then we also help our clients with the filing of annual return under the Act. Very, very important. So, if this doesn't get filed, it's a non-compliance under the law. Apart from this law, there are disclosures required under other laws. Let me briefly pick them up. One is under the Companies Act. Like I said, the director's report or the board's report must contain a statement that the company has complied with the provision relating to ICC under Sexual Harassment of Women at Workplace Act. SEBI regulations also require listed companies to disclose in the section on the corporate governance of the annual report regarding the number of complaints filed for financial year, disposed of, and complaints pending as on the end of financial year. So these two compliances are for financial year. However, the annual return that gets filed with the Labour Office under the POSH Act is for the calendar year, Jan to December. That's the difference. So very interesting. So let's stop sexual harassment before it occurs. And this, I believe, is the last slide before I conclude today's webinar. STOP has been used here as an acronym. So S stands for the source. The source source of such behavior has the responsibility to stop behaving in such a manner. And the target should confront the source because he might not be aware that his behavior is offensive to the target. And therefore, the target, like I said, should start saying no in the first instance. The observer or the people around us working in the organization or who know that something incorrect is happening, those who observe such kind of behavior have the responsibility to stop it. And one who notices such behavior is never an innocent bystander. So who notices and doesn't stop such behavior is not an innocent bystander. And the P stands for person in authority, or the management, or the board, or the person who is in authority at that place. He is responsible to keep the workplace free from such kind of behavior and create a respectful workplace. So thank you so much for attending the webinar, and I look forward to help you in your business. My contacts are mentioned here. Anytime you have a question, you may please get in touch with me. All right. So like I said, we have been, so eMindsLegal is a 12-year-old law firm, and we've been supporting clients not only for their legal requirements under various laws like corporate laws, FEMA laws, accounting, taxation, payroll, etc., etc. POSH is something which is personally very close to my heart because I've been practicing under this law, handling various investigations. So in case any of you requires any help, you may please get in touch with me, or you may please get in touch with Complinity team, and they will pass on the message. Thank you so much for sparing your time and attending today's webinar. All the best to all of you. Thank you so much.
Welcome to Complinity Technologies. Complinity is India's leading governance, risk and compliance software helping companies to manage their compliance, contracts, litigation, legal updates, inter-financial controls and more. Complinity is a one-stop shop for all GRC needs. With our proprietary 12 GRC modules and real-time legal updates on 2,000+ laws and 24,000+ compliances. All in an integrated platform that is easy to use with automated alerts and risk management capabilities. Is why compliance managers, general counsels and chief financial officers choose Complinity every time. Join the most innovative and prestigious brands that use Complinity. Automating your compliance management. Request a demo at complinity.com.